Very good afternoon to all my dearest student friends. Indeed, it gives me a great deal of pleasure to deliberate on data protection and privacy. So, after my deliberation, one will be able to describe how the evolution of right to privacy actually took place and what are the key elements and the principles of data protection and that too in India. So apart from that, also one will be able to answer the Information Technology Act 2000 and the provisions contained therein and all are relating to data protection. Apart from that, one will be able to know the necessity for specific data protection legislations. And one will also be able to explain what is the state of the data protection framework in India. And you will also appreciate the provisions of the Personal Data Protection Bill in 2019. So the deliberation will have a structure like this. Initially, I will give you the introduction regarding the data protection and privacy and what is privacy as an evolving concept and that too in the digital context because we are talking of 2023 and then to follow that the right to privacy in India and the Information Technology Act apart from the right to privacy and what is the right to privacy and the necessity for specific data protection laws, the Personal Data Protection Bill 2019. So to start with, the data protection when we are talking of, obviously, what we look at, we are all living in a world in which we find that things are changing. And when things are changing, and each and every second of our life, we create millions of bits of data about us. For example, suppose somebody is making keystroke when we make on our phones. Don't you feel that we convey some kind of extensive data about us? So this will include, but is not limited to several personal aspects of our life, like what time we get off early in the morning, or how much time normally we spend on our telephone, or what kind of application that we are going to use in daily basis, or the person with whom we communicate. These are all relating to our personal aspects with whom we communicate the most. But what we prefer to eat, what we prefer, obviously you would like to go for shopping, what you would prefer, like your what is the current health condition of the person, what we prefer, always we prefer to travel, see places, what we want to travel and which movie we want to watch next. So similarly, every financial transaction normally we do, and that too we do digitally within our outside our phones. That creates an extensive data about our financial behavior. So the fact remains that if you are a fitness tracker user, even your movements within and outside the home may be creating diverse data about your physical activities. Similarly, we have individual bits of data about us may not always be problematic because the aggregation of data, which is more important, that can result in detailed profiling of the individuals with enormous consequences. So the use of data, and that too for the targeted advertisements, the use of data and that too for personalized advertisements is just one of the many such consequences for the privacy rights of individual. So unfortunately, it would be appropriate to mention one thing that most of the data gathering happens without having any explicit permission from us, and far too often without any notification of the gathering of data. So therefore, a robust data protection framework is very necessary. Therefore, a robust protection framework is very much necessary for protecting, you can say, the privacy rights of individuals. So, my discussion will provide an overview of the current legislative policy, and not only legislative but also policy framework regarding the privacy rights, regarding the data protection in India. So to start with the privacy, and when I say privacy, privacy is an evolving concept in the digital world. The primary factors, in fact, that necessitated the evolution of privacy rights was the need to safeguard and need to preserve the dignity of an individual, and consequently preventing some kind of unauthorized disclosure of personal information in the public domain. So, as it is, we know that it is defined by Samuel D. Warren and Louis D. Brandeis, two among the earliest scholars who contributed immensely to the evolution of privacy laws. That it is all defined that privacy is a concept and encompassing the inviolate personality of a person, which doesn't include within its ambit matters which are privileged, published with consent or existing in the public domain. So, over the years, privacy rights have risen to become one of the most prominent factors for facilitating the self definition, irrespective of whether you are an individual who is in the public or whether you are an individual who is in a private space. But one thing that is more essential here, but with the advent of the digital age, obviously the scale of data produced and the scale of data used have changed dramatically. In fact, it would be appropriate to say the ability to store large swathes of data and their subsequent analysis using diverse data mining techniques, in fact, have unearthed unprecedented opportunities for firms to use and trade on personal data, because the first development in the area of AI, that is your artificial intelligence, further today contributes to unparalleled challenges to privacy, contribute to unparalleled challenges to autonomy. So, in fact, the manner in which the digital revolution impacts privacy, particularly the concerns with regard to the misuse, with regard to the manipulation of personal information, because both have also given rise to the concept of informational privacy. So while anecdotal accounts might suggest that some kind of awareness about privacy rights might be improving among the public due to the diverse discussion on privacy in the mainstream media as well as social media. So most people still rarely hesitate to surrender their informational privacy, and that is in return for the receipt of free services. That is in return for a receipt of your better services, or you may say convenience in the digital context. The manner in which most of us share our location data, say, with so many applications on our phones, or even we are using smartwatches, is just one of the many examples in this regard. At times also, firms might also not give consumers any kind of choice. And when a firm takes an approach that they will allow consumers to use their services only if they agree to the data policies of the firm, obviously, in that case, the consumers are often left with no choices. So, but they have to agree to the terms of the firm. So it is in the broader context rather that we need strong legislative frameworks. We need strong policy frameworks. Because why do we need strong legislative framework? Why do we need strong policy framework that can protect the privacy rights of consumers? So my deliberation to trace the evolution of the right to privacy and other key elements and other key principles for data protection in India. So accordingly, so the deliberation firstly deals with the first page, the evolution of privacy as a right in India, in particular through judicial pronouncements. The second page of my deliberation will be Information Technology Act 2000 and what are the provisions contained therein, that too relating to data protection. And the third, the need for specific data protection legislations. And the fourth, the state of the data protection framework in India, keeping in view the aspects which receives elaboration through discussion, like salient features of Justice Sri Krishna Committee report and the Personal Data Protection Bill of 2018. And discussion of the sixth page will be on the provision of the Personal Data Protection Bill 2019 with special reference to the department which has made from the 2018 bill. Now coming to the right to privacy in India, obviously we look at India, we look at the Constitution of India. Well, the Constitution of India doesn't explicitly mention the right to privacy. Obviously, the courts in India have dealt with the question of whether privacy is a fundamental right in India. So there was case MP Sharma versus Satish Chandra, and the case decided by an 8-judge bench of the Supreme Court dealing with the question regarding the legitimacy of the search warrant issued under Section 96(1) of the Criminal Procedure Code 1973, and was the first ever case to touch upon the aspects related to privacy. So the apex court has, that case, held that the fundamental right to privacy was not a guaranteed right under the Indian Constitution. So this position again was reiterated in the Kharak Singh versus State of Uttar Pradesh, and however the case was held tapping of telephones to be an infringement of the right to privacy. Again, another Selvi versus State of Karnataka case also which came up and which declared that the use of investigation techniques, including our polygraph or narco analysis or BIP, without the prior consent of an individual, amounting to violation of an individual's privacy, necessitated the need to resolve the conundrum regarding the status of the right to privacy under the constitutions. So finally, the larger branch of the Supreme Court had the opportunity to address the question in case Puraswamy versus Union of India, and the case arose in fact in the context of Aadhaar, the biometric ID system of the Government of India. So in this case, the constitutional validity of Aadhaar was challenged, and the constitutional validity of Aadhaar was challenged on the ground that it violated the right to privacy of an individual. So it was contended that the Aadhaar posed a serious threat to an individual's privacy by compromising on their bodily integrity, as it required collection of biometric information, as is required also the storage of biometric information for authentication, your fingerprints, iris scans, opening up possibilities for misuse also cannot be overruled. So further, the collection of the personal information also heightened the risk regarding the data security. And this is coupled with the dangers which were associated in relation to data storage, which was associated with relation to your data breaches. So the judgment of the Supreme Court in the case dismissed many key aspects that lay down the essential principles in relation to guarantee protection and promotion of the right to privacy and the fulfillment of the right to privacy. So the then judge that J. Chandrachud, held that the right to privacy is an aspect of human dignity and is a basic natural right. He also made observation regarding informational privacy and the impact of privacy and that too in the digital economy that we are talking of today, and highlighted the requirement of the data protection law. So, Chelameswar J held the privacy consists of three major elements. One is that means what was reposed, that means freedom from groundless stimuli, and your sanctuary, that is your safeguarding against invasive observation, and the third, that is your intimate decision. That means you should have freedom to make personal life choices. You should have freedom to make intimate life choices. And Paul J emphasized on the claim that the state actors, that means issue of surveillance and the profiling, or non-state actors like your technological influence, which encompass collection or the storage or the dissemination that you are talking of big data. So the judgment also discussed the elements of judicial review and how they can be accommodated in cases of invasion into privacy by the state. So Chemaleswari J highlighted the significance of the idea and the concept of reasonableness in the part 3 of the Constitution and its varying role, that too when we are talking of varying role depending on the right in question. So by stating that the infringement of privacy may be due to arbitrary action, arbitrary action of the state would exact testing its reasonableness under Act 14, violation of privacy with respect to Art 19 must fall within the exceptional, provided the actions infringing your Art 21 must be just, the action infringing must be fair, the action infringing must also be reasonable, and including instances requiring that maintenance of highest standard of scrutiny, which can only be warranted in case of compelling state interest. So Nariman J also cited instances to assert that the restrictions on privacy must be tested on the combination of rights being encroached. Likewise, arguments were made and combined reading opinion of Chandrachud J, who wrote on behalf of 4 judges, including himself, and Call J, can provide a clear picture of the legal test of infringement of privacy in India. So that is why the test suggests the need for looking at 4 elements. What are those 4 elements? The first element is the legality, that is the presence of law. The second element, that is the legitimate goal, that is the law made must be for a legitimate state aim. And the third, that is the existence of a rational connection between the aim which is sought to be achieved and the privacy infringing state action. And the fourth element, that the test of proportionality. That means there must exist a rational nexus between the object that needs to be achieved and the means. Finally, the court directed the union government to set up a data protection regime for safeguarding individual interest in relation to infringement of privacy. And pursuant to the judgment, the government also formed a committee of experts under the leadership of Justice B.A. Sri Krishna. And the committee's job was to consider all issues relating to data protection. And the committee should come up with a draft legislation thereon. And the recommendation of the committee and the subsequent legislative developments, which we'll be discussing in the due course of time. So now coming to the Information Technology Act and the right to privacy, though not legislation drafted primarily with a purpose, with a view, or with the aim of privacy protection in the digital context, some of the provisions of the Information Technology Act 2000, that means IT Act 2000, have implications for privacy protection. For example, I would say the section 43A of IT Act deals with the compensation. I mean, this compensation for failure to protect data. This compensation for failure to give clarification that an enterprise handling any sensitive personal data or information can be held liable for causing any wrongful gains or wrongful loss by being negligent in establishing reasonable security practices or procedures in handling any information. So while this statute doesn't define sensitive personal data, so the term data has been given a very broad definition in the statute. It is defined as the representation of information. It is defined as an interpretation of your knowledge, interpretation of your facts. It is defined as your interpretation of concepts. It is defined as your interpretation of instructions which are being prepared or which are being prepared in a more formalized manner. And that is also intended to be processed and is being processed, or it has been processed. And for that, you have taken the help of the computer system, in a computer system, or through a computer network, maybe in the form of computer printouts, magnetic or optical storage media, or punch card, or punch tapes, or you can go for storing internally in the memory of the computer. Similarly, Rule 3 of the IT Rules 2011 has, however, I would say, provided the definition for your sensitive personal data or sensitive personal information. And as per the rule, sensitive data or the information of a person means such type of information which consists of information relating to password, information relating to financial information such as bank account, credit card, debit card, or other payment instrument details, your physical, your physiological, your mental health, the health conditions, the sexual orientations, your medical records, medical history, biometric informations, any detail. That means any detail in the above clause as provided to body corporate for providing some kind of service, or any information received under the clause by any body corporate for processing, for storing, for or processed under lawful contract or otherwise. But however, Rule 3 also clarifies that any information which is available in the public domain or any information which is published under the law will not fall within the purview of the provisions. So that is why we have Section 66E of the IT Act. They deal with voyeurism and provides that any person who willfully captures, any person who publishes or disseminates the image of a private part of any individual without consent, that will lead to your violation of their privacy and shall be also liable to punishment. And the punishment is such, the punishment can be with imprisonment. With the imprisonment can also be extended up to 3 years, or you can also be fined for an amount not more than 2 lakhs of rupees, or with both. Similarly, we have Section 72 of the IT Act. It provides some kind of penalty, and The penalty for breach of confidentiality, the penalty for breach of privacy by statutory authority, because they are all empowered under the Act, IT Act, to secure access to private information. The information which are in the form of record, the information which are in the form of book, for its consequent disclosure to the third person without taking the consent of the person concerned. So, as per the provision, the violators may face even imprisonment up to 2 years, or the violator may be fined up to 1 lakh of rupees, or both imprisonment and the fine. Similarly, if you look at section 72A, it provides punishment for disclosure of information in breach of lawful contract by any kind of person, including an intermediary who has gotten access to personal information about the person, or you have not taken his consent, discloses it to another with an intent to cause wrongful loss or wrongful gain. So this prescribed, no doubt about it, punishment. When we are talking of punishment today, it's an imprisonment up to 3 years of time, or fine which can go up to 5 lakhs rupees, or both. So the transfer of personal data is very much regulated by the information technology, reasonable security practices and procedures, and the sensitive personal data or information rules 2011. Because Rule 4 directs the body corporate collecting information, body corporate receiving information, body corporate storing information to provide some kind of privacy policy for dealing with the personal information, and to give guarantee that the same can be viewed by the providers of such informations. So this rule further directs the corporate body or any person who is working on behalf on its behalf to publish on the website the statements, the type, the purpose of collection, the reasonable scrutiny practices employed by the farmer. So Rule 5 provides that the collection of information by a body corporate shall be done only after obtaining consent. And the consent has to be obtained in writing from the provider of the information. So Rule 6 provides that the disclosure, when we are talking of the disclosure, it is the disclosure of the consent, and it must be obtained from the provider of the information where it is required for complying with any kind of legal obligation. So that is why Rule 7 lays down that the transfer of any information to any other body, happens to be corporate located in India or any other country, shall only be done maybe with the consent of the provider, after guaranteeing that the level of data protection which have been offered, there is a commensurate with these rules. So as we can see, some of these provisions do deal with the protection of privacy rights. However, it is not indisputable that the effectiveness of these provisions and the adequacy of these provisions have been properly dealt with. So in all these cases, what is more important, the provisions were increasingly proving inadequate to deal with the increased amount of such data breaches. Now coming to the right to privacy and the need for specific data protection laws. As a matter of fact, the protection of privacy in the current digital world, in the current digital context, in fact, it requires framing of specific policies, framing of specific procedures which can minimize the intrusion of both private persons, including companies, and the state into privacy of an individuals by generating, by collecting, by storing, by using, and by collating or deriving data about the individual. So, for the purpose of discussion, data can be categorized into, I would say, two categories like personal data and non-personal data. When you are talking of personal data, one thing we have to remember, it includes characteristics, it includes traits which can um, uh, which may be used to identify individuals, or with maybe non-personal data on the other hand encompasses your aggregated data, which may not serve in identifying an individuals. So if you look at the data protection approach, obviously the United States, the China, Europe, one can see them making diverging approaches to data protection, which are based on their respective socio-political requirements and their outlooks. For example, the United States pursues a somewhat less fair approach, and that is why United Nations, they are all so they are all seeing not too keen to have a specific comprehensive legislative framework for data protection, but with the emphasis which are always given the emphasis traditionally being on protection of your business interests and the deregulations. So US uses some kind of amalgamation of constitutional provisions and not have a unified data protection legislation like that of European unions. The we have to make reference from numerous sector specific, and apart from that, the directive provided a framework for processing a personal data and took the approach of drafting comprehensive privacy legislation, also with your great emphasis on your protection of users' right through extensive discussion among the members act to enact. But the general data protection regulation under this legislation, maybe the state is very much interested and with the strengthening, with the very purpose of strengthening the individual's privacy, and when strengthening their individual privacy in the digital era, and for you can say laying down the privacy into maybe rules as regards the companies and the public bodies. So now coming to the data protection framework in India, it may be recalled from the discussion, or whatever I have been able to make till now. In the Puttaswamy decision, the court had categorically mentioned the need for an appropriate data protection framework in India. So in July 2017, the Indian government decided to form a committee to study various dimensions of data protection and suggest the inputs for an appropriate legislative framework in the area. So under the chairmanship of Justice retired D.N. Sri Krishna, the committee gave a very comprehensive report delineating the rationale for a very robust legal framework for your data protection, and the committee also provided the draft personal data protection bill. So, if we look at the key aspects of the Justice Sri Krishna Committee report, in fact, the report defined personal information to include any data which may be used to identify an individuals, either it is directly done or indirectly done, but the personal data was defined on the basis of their identifiability and with the law, including processing by private and the public entities. So it is seen that sensitive personal data was to include financial information and was very purpose for the password, health information, your religious, political informations, with the Data Protection Authority, which empowered to include further categories as and when it is issued by them. So the committee also sought to differentiate the personal data protection from the protection of sensitive personal data. So that is why the committee noted that the relationship between the individual and any service provider must be observed to be a fiduciary relationship. That means when you are talking about a fiduciary relationship, that means a relationship which is based on fundamental expectation of trust between the two parties, master servant, doctor patient, and that should be there should be a very fine balancing of interest between the two. So this conception of this relationship also led to the committee for the purpose of adopting the terminology of data principles and data fiduciary as opposed to the terminology used in other data process protection legislations in the world, that is as that of data object or data controller. So, what was beneficiary that the establishment of the regulatory framework originates from the fact that there is a need for protecting the rights of an individuals, referred to as data principal, and who is the focal actor in the digital ecosystem, and that too with reference to their personal data. So, the basis of a fiduciary relationship is the expectation by an individual regarding fair use of his data or her data for legitimate purpose. So that is why there it arises the duty on the part of the entities collecting the data for dealing with the data responsibly. So that entities are referred to data fiduciaries. Then the draft bill suggested about the regulation of the personal data, providing rules for protection of autonomy of individuals with reference to their data, along with laying down the norms for protecting or for collecting or for the purpose of storage of such data by the, you can say, data processing entities. So the report provided a number of recommendations, starting with the need for setting up an independent regulatory authority and the Data Protection Authority, which would be entrusted with the enforcement of the law. So, a Data Protection Authority, as per the suggestions of the report, shall be empowered to classify certain data fiduciaries as significant data fiduciaries depending on their power to cause greater harm in pursuance of their data processing techniques. So, data fiduciaries have been mandated to undertake the obligations, including consenting to data units and consenting the data protection and data protection impact assessments, along with you can say getting registered with the DPA, that is Data Protection Authority. So that is how DPA, Data Protection Authority, was also bestowed with the enforcement mechanism, empowering them to issue direction, empowering them calling for information, empowering them publishing guidance, empowering them codes of practice to be followed, providing injunctive measures while carrying out inquiry or issuing warnings. So establishment of an appellate tribunal for adjudicating or disposing of appeals against any order passed by your Data Protection Authority also found place in the suggestion in the committee report. And now coming to the personal protection bill, personal data, when I say personal protection bill, that means the Personal Data Protection Bill 2019. So the Personal Data Protection Bill 2019 was introduced in the Lok Sabha on 11th December 2019, and it was subsequently forwarded to a joint parliamentary committee. And while the bill has retained many elements of the draft bill, because the draft was provided by Sri Krishna committee, it has also made some radical changes where you have the major differences between draft bill provided by Sri Krishna committee and the bill which was introduced in the Lok Sabha. So they said that the definition of personal data is defined in a way so as to include certain characteristics, so as to include certain traits, so as to include certain attributes of identity used to identify an individual, was expanded, also include any inference being drawn from such data for profiling purposes. So the definition of sensitive personal data, which included the passwords as per the uh, bill proposed by the Sri Krishna committee, was also amended to remove password from under this category, because the power to category personal data as sensitive personal data, which was in fact conferred upon the Data Protection Authority under the draft bill, has been granted by the central government in consonance with Data Protection Authority under the 2019 bill. So, Sri Krishna committee bill has no reference to social media intermediaries. However, 2019 data that protection bill not only provided a definition for further necessitated social media intermediaries classified as they are also significant data fiduciaries to provide a voluntary user verification mechanism for all users. So this had also further exempted the any state from abiding by the requirements of the bill while processing personal data in the interest of the national security. But one thing, as long as it was permissible under the law and performed in a very fair manner, performed in a very reasonable manner, the 2019, on the other hand, grants the government the power to exempt any of its agencies from the provision of the Act in certain cases. So, your data protection authority, and when we are talking of PDP, so that bill 2019 PDP bill incorporates data subject rights such as right to erasure, granting the right to the data principal to request data fiduciaries for erasing any kind of personal data that may have been stored by the latter ones for the purpose has been fulfilled. So the composition of the data protection authority also subjected to certain modification in the 2019 PDP bill. Under the Sri Krishna Committee bill, the selection committee was empowered to give recommendation to the central government for the appointment of the members of the Data Protection Authority, comprised of Chief Justice of India or any judge of Supreme Court as per the chairperson, and cabinet secretary or any expert in the field of data protection, information technology or its related subject as member. But however, 2019 bill, I would say, does away with the requirement of a judicial member from the selection committee. So that is why selection committee as per 2019 bill consists of cabinet secretary as the chairperson, secretary department of legal affairs, secretary ministry of electronics and information technology was also taken as the member. So in all these cases, what is more important that we have to see that whether it is a personal data or the recommendation which has come, but one thing that is very clear, that as per the suggestion of the report, the consent was considered to be mandatory for processing of personal data. So the report suggests the adoption of a modified consent framework where data fiduciaries shall be held liable for any harm falling on the personal, on the data principle. So consent needs to be free, consent needs to be very specific, consent needs to be very clear, consent needs to be informed, consent should be capable of being withdrawn in order to be valid. So the report also suggests that the processing of personal data by the fiduciaries must be fair. The processing of personal data by the fiduciaries must also be reasonable, because data fiduciaries shall be bound to follow the principles of purpose limitations. So because data fiduciaries shall use the personal data so collected only for the purpose for which data principal expects it to be used. The transparency, providing notice. When I say providing notice, right at the time of collection of personal data. Similarly, storage limitations, storage of data only for the time period required to fulfill the purpose for which it was collected, not beyond that. So processing cannot be performed in the absence of an express consent by the data principal unless the purpose for the same has been communicated at the time of collections. So committee recommended the inclusion of data principal rights such as right to confirmation. When I say right to confirmation, that means data principal's right to inquire about the processing of his data and getting access. When I say access means right of the data principal to obtain access to his personal data, which is in the control of the data fiduciary. And apart from that, also the correction, the right to data portability. That means the right to receive the data, right to transfer the data, which is stored with the data fiduciaries, because right to object to processing, right to object to direct marketing, and the right to be forgotten, because right of the data principles to delete, to amend, or to correct the information that may be disclosed in the internet by the data fiduciary. So the bill, that means draft bill, also proposed a three-tier system based on the data localization requirements, because data has been categorized. One is your personal data, another is your sensitive personal data, another is your critical personal data. While personal data may be allowed to be transferred freely, but sensitive data may be transferred only after obtaining explicit consent by the data principal, and which must be very clear. And in that case, the or subject to government approval. But when we are talking of the third category, that is the critical personal data, that may be transferred except on very limited grounds, because there is cross-border transfer of data. Apart from your critical personal data, not subject to cross-border transfer, which may only be processed in India, may be done with the help of a model contract containing certain clauses holding the transfer liable for any harm if at all caused to the data principal due to violation of the law. So that is why the committee also provided grounds where processing may be done on non-consensual grounds, which include welfare functions of the state, which includes your compliance with any law or the order of the court, order of the tribunal, or any other reasonable, or any other, because the purpose must be reasonable. Further, the processing of personal data or the processing of sensitive personal data may be exempted in certain cases, because in certain situations, including in the interest of security of the state, if there is involvement of the security of the state interest, or for personal purpose, or for domestic purpose, or there should be disclosure of personal data for the purpose of legal proceedings, for the facts in contravention for any law in force, because personal purposes and the mutual processing may it may be by small entities, so that will lay down that the data protection authority may levy penalties on the data fiduciaries if there will be some kind of failure to comply with the data processing obligations, or failure to comply the directions so issued by the data protection authority, or cross-border data storage or transfer requirements. So the report, along with the draft, was submitted to the Ministry of Electronics and Information Technology on July 27, 2018. And that is how, when we again coming back to the Personal Data Protection Bill 2019, that is also seen the composition, that is because data protection, the Personal Data Protections Bill, that is also seen as the composition, because data composition of the Data Protection Authority was also subject to certain modifications. So in that case, the under the Sri Krishna Committee Bill, in the selection committee of the appointment, which was there Chief Justice of India, subsequently it became the Cabinet Secretary as the chairperson, and the Secretary, Department of Legal Affairs, Secretary, Ministry of Electronics and Information Technology as the member. So while Sri Krishna Committee Bill neither defined non-personal data nor envisaged applications for non-personal data by the government for making policies for the digital economy, and that is why the because in addition to defining the term, also empowers the government. What kind of empowerment was made available to the government? To direct. The empowerment came in the form of direction. The government can direct the data fiduciaries to provide any kind of non-personal data or anonymized personal data for better targeting of provision of services. And additionally, the 2019 PDP bill has brought forth the concept of privacy by your design policy, whereby every data fiduciary has to prepare a privacy by design policy and get it approved by the Data Protection Authority. So the Supreme Court has clarified through the landmark decision of Puttoswamy case, the right to privacy is a fundamental right in India, like many other fundamental rights. While the privacy right cannot be considered as an absolute right, as I told you, it is very important that effective measures, it is very important that adequate measures are put in place to protect the privacy right, particularly, I must say, in the current digital context, wherein there is a threat. Threat of what? Threat of infringement. By whom? By the actors, including the state is non-trivial, including the state is profound. So a robust data protection regime can better assure the best possible protection of privacy rights for individuals. That is the, in fact, that is, I must tell you, that is the need of the time. So the key principles laid down by the Supreme Court in the Puttoswamy decision has been a good starting point for designing a very robust data protection regime for India. Because the report of the Joint Parliamentary Committee on the Personal Data Protection Bill has been tabled between the House of the Parliament on 16th, 2021 with a bill titled the Data Protection Bill 2021, because the bill looks at one thing, it is looking to regulate not just the personal data as was envisaged by the Sri Krishna Committee, but also it includes within the scope of personal data until a framework to differentiate between the personal and non-personal data is set up by the government. So that is how always we look for one thing, that we have to see that the protection of data in the three category has to be there. So it is the privacy must be protected. So in all these cases, protection of privacy is very much required in the current digital context. So because digital context, they require framing of specific policies, they require framing of procedures. Because if you have policies, you have procedures, it can minimize the intrusion of both private persons, excluding, why excluding? Including the companies and the state into the privacy of an individual. And that is by generating data that is by collecting data, that is by storing data, that is by using data, even that is by collating data, even for that is from deriving data about the individuals. So the purpose of the discussion that data can be categorized, and the data includes certain characteristics, traits, which may be used to identify the individual, while non-personal data, on the other hand, encompasses aggregated data which may not serve in identifying an individual. So if you look at the data protection approach in the United States or the China or the Europe, one can see them taking diverging approaches to data protection based on their respective socio-political requirements, based on their outlooks. But in India, we have developed a very robust data protection framework to safeguard the interest of different bodies. So that is how when we look for the data protection, whether at the personal level or whether it is the Sri Krishna committee, whether it is the composition of data protection authority, but the fact remains that as the Supreme Court has in fact clarified through its decision in the Putswamy case pertaining to the right to privacy, which is a fundamental right in India. So many other fundamental rights, while even privacy right cannot be considered as an absolute, you can say, right. It is very important that effective measures, it is very important that adequate measures, they are all put in place. Why they are all put in place? What is the reason behind it? The reason being, how do we protect privacy rights, and particularly in the current digital context, where you find that there is a threat. It is a threat of infringement. By whom? It is a threat of infringement by the actors, and including your state. And it is the state is, because including the state, that is non-trivial and that is profound. So one should have a robust data protection regime, and the robust data protection regime in fact can assure the best policy protection of privacy, and this is a policy of best protection of privacy rights for the individual. In fact, that is the need of the hour, that is the need of the time. So that is why the key principles which was laid down by the Supreme Court in the Putswamy decision has a very good starting point for designing a very robust data protection regime for India. So with this, we come to an end of today's session. Thank you very much. Have a nice time. Good day.